Case briefs and so much more. LSData's got what you're looking for.
A critical case of 2012, Quilloin vs. Tenet HealthSystem. Philadelphia, Inc., heard by the United States Court of Appeals for the Third Circuit, focused on the nuanced area of arbitration agreements in employment contracts. In essence, the case revolved around the question of whether the Federal Arbitration Act, FAA, holds sway in establishing the validity and enforceability of such an agreement, even when concerns about its fairness or transparency arise. At the center of the dispute was Janice Quilloin, a former employee of Tenet Healthcare Corporation who had signed an arbitration agreement that detailed an internal grievance process culminating in arbitration. Quilloin challenged the fairness of the agreement, which led her to the district court. Contrary to her expectations, the district court did not rule in her favor and hence denied the motion to compel arbitration. In response to the adverse ruling, Tenet Healthcare appealed the decision to the United States Court of Appeals for the Third Circuit. The appellate court honed in on the arbitration agreement's clause that prohibited the recovery of attorneys' fees and costs. It ruled that this particular provision was out of step with federal statutes. The Court of Appeals also concluded that the arbitration agreement was not procedurally unconscionable, implying that the district court had erred in denying Tenet's motion to compel arbitration. The Court of Appeals, therefore, upheld the validity of the arbitration agreement in Quilloin's case. It was emphatic in its decision that the agreement was not unfair and was not designed to unduly favor the employer. Threading a path of arbitration jurisprudence, the court established that issues about attorneys' fees or class action bans should be determined by arbitrators, not courts. As such, the Court of Appeals found that the district court was misguided in denying Tenet's arbitration demand. This led to the overturning of the district court's decision, leading to a halt in litigation proceedings.
Case briefs and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.